Right now, many of you hear the name Ed Gudeman a lot on this show, of course. I've known Ed for a lot of years. Ed Gudeman, of course, of Gudeman and Associates. He is the one who did the will and the trust for my wife and I. And, you know, I I've said this, I've told the story many times that I used to believe that wills were just for people that were rich. I'm not rich. And so it's like, okay, well, do we really need a will? Do you really need a will and a trust? And then I started doing some research into this, looking at this, talking to Ed, and I realized, oh my goodness, everybody needs to have a will and a trust and get this done once and for all so your kids don't end up in probate someday. And Ed Gudeman of Wills and Trusts Now joins me live right now. We're going to talk about this a little bit. Hey, Ed, how you doing?
Very well, Bob.
Good. Always good talking with you. I do want to ask you about the thing that I was saying in the introduction here, though. I think a lot of people think like I used to think, Ed, that well, if you're not really rich, do you actually really need a will? Explain why a will and a trust really is important for everybody, not just the gazillionaires out there.
Okay, well, very basically, a will is something that you execute that makes sure that your property goes to those people that you want it to go to.
Hmm.
In absence of a will, you're subject to what we call intestacy, meaning dying without a will. And the state has a formula and a statute that tells where your property is going to go. No ifs, ands, or buts.
Hmm.
So if you want to control your own destiny, you should have at least a will. However, if you have a trust, and even if you have a modest estate, you have a trust, you can avoid probate, which means that your family, loved ones, whoever you want your property to go to, will have much less of a problem. They don't need to go to court. They don't need to spend thousands of dollars on filing a probate action, hiring an attorney to get you through this. The probate process typically takes as long as 9 months, 12 months, even longer, sometimes a year, year and a half, depending on whether people are contesting what is in the will or things of that nature. So all that can be avoided by a will and a trust. But at a minimum, people should have a will.
Okay. Now, what about sometimes people think, well, hey, as long as I scribble something on a piece of paper, I should be covered, right? That actually doesn't hold up and is not as enforceable as people assume it is.
That's an understatement. Yeah.
I know.
I think people are familiar with Aretha Franklin's situation where they found 14
Right.
wills, and they went on probate fight, and I think it cost like $5 million of
Mm.
legal fees or something
Wow.
idiotic like that. And they ended up settling the case, and I guess everybody went away, with something.
Mhm.
But again, all that can be avoided. Just writing something down in what we call a holographic will does not necessarily mean you have a binding document.
Mhm.
It's subject to attack, and can't recommend that you do holographic wills.
Right, right. Well, and that's why it's so important, I think, for people to get this done and get it done right. And one of the things, and help us understand a trust. I know we talked about wills mainly. You touched on trust a little bit, but people say, well, okay, what's the benefit of having a will and a trust instead of just a will? Why is a trust? Because we have a trust for my wife and I too. And we're not rich, but explain to my listeners why that actually makes sense to have that with your will.
Well, again, the main reason for having a trust is avoiding probate and making sure
Mhm.
that are handled the way you want. And interestingly, a trust allows you to control the disbursement of your monies to your family, friends, your beneficiaries as you see fit, even though you are deceased.
Mhm.
So, for instance, there's a lot of times where there's young children involved, and if you don't have a trust or something that says, what controls their money, when they're 18, they're entitled to whatever, is there for them. Whereas a trust can be set up to control that money so that, money isn't necessarily going to people who aren't mature enough to handle money.
Right.
Uh, and you can designate it for their health, education, welfare, and maintenance, which is what lawyers call a term of art, but they're a definitive standard.
Right.
So, but you can say that the money is going to go for their college education, or you want it to go for perhaps the purchase of a residence or a car, or all the above. And you can also designate monies to go to people who would be secondary beneficiaries or even third level beneficiaries. So let's say, for instance, you have children and you predecease uh, your parents, and the parents have some money going to you. You can set it up so that your children would take what you would have had, and uh, or you can set it up to have to go to charities or whatever you prefer.
Mhm.
Um, it gives you a lot of flexibility. But I want to return to a question that you asked. What is a trust?
Yeah.
Okay. A trust is just a very large third-party beneficiary contract. Now, what a third-party beneficiary contract, I can best describe by example. Let's say, Bob, you hired me to take care of your wife and or your children.
All right.
In okay?
Mm-hmm.
Uh, I'd be the fiduciary here because I'm signing up to take on a job that you're giving me, and your wife and children would be the beneficiaries of your trust, your document, your
Mm-hmm.
third party beneficiary contract. Under US law, beneficiaries of third party beneficiary contracts, even though they're not the contracting parties, can enforce that on me, the trustee in this example, if I'm not acting the way I'm supposed to according to that document. Okay, so a trust is
Okay.
much like that, only as I tell my clients, it's on steroids.
Huh.
But it's that's the way it works. It's just a fancy contract, and
Right.
it serves a major purpose in handling people's affairs the way they want them to be handled, as opposed to leaving it to the courts or other people to determine how it's going to be handled.
One of the things that, and I've talked about this before, Ed, that the last thing that any parents want, okay, their kids are maybe, whether they're young or whether their kids are adult, either one, the last thing that parents want is if something happens to them for the siblings to not get along with each other, to end up being fractured and disconnected from each other and fighting and such. So no parents want that to happen. And one of the problems I think a lot of people don't realize is if you don't have a will and a trust done, it doesn't matter how well the siblings all get along with each other. It's very common, and I know you've seen this a lot, where families, brothers and sisters, that were never at each other's throats before now suddenly become enemies with each other, and they end up getting their own lawyers apiece and fighting things and probate, whatever. And it's like, oh, that would just break mom and dad's heart if they knew that the brothers and sisters were suddenly at each other's throats. But a will and a trust, it really does eliminate that because it's taking it out of their hands. So you don't have some third party making decisions for the kids.
That's correct. And the more specific that you can be in a trust, and what I tell my clients, and your listeners should know, that as long as a trust is written clearly and unambiguously, the courts will enforce those provisions.
Hmm.
Very often, the fact that, some people come in here and they say, well, I don't like this or that provision that my parents had in here. Can you break this trust and so forth? And unfortunately, many times I have to tell them that it's not likely I can break a trust. I mean, I don't like to take people's money unnecessarily.
Right.
Uh, in fact, one of the first clients I ever had when I was just out of law school and just started my practice, a young woman came in. She wanted me to break a trust. And I told her, as much as I wanted clients at that time, that I could not take her as a client because I thought she would lose.
Hmm.
She wanted me to break what is known as a testamentary trust, which is one that's in a will, as opposed
Yeah.
to a revocable trust, which is one that we mostly do for people who come in as clients.
Mhm.
And she went to another attorney who took a lot of money from her. This is back in the 70s. And he lost, as I expected he would. And she came back to me and said, you were the only person who told me the truth about this. Now what do I do? Well, she had a 6-year-old daughter. And I said, well, you better get a job and
Mm.
take care of your daughter. Now, the punchline of all this, or as Paul Harvey used to say
Mm.
on page 2,
Right.
um, the amount of money put away for her was $50 million,
Wow.
but she was allowed to touch it. Not a dime was to go to her until she was age 50. She was only 28 when she came to my office. And she, the judge had ruled that the document had been done properly. There was no undue influence, no fraud, no duress in making up this document. and she had to live with that.
Hmm.
Now, the page three, perhaps, is that when she finally got to be age 50, and she's still alive, by the
Yeah.
way, she got $110 million because the trustees had done a really great job for her, even
Sure.
though, you know, she wasn't a high income earning person, but she got by, and, that's what happened.
That's great.
But that's her parents set it up for that, and
Hmm.
sometimes it's unfortunate as to what happens. I think her parents, who I obviously never met, wanted to punish her for some reason,
Yeah.
or didn't trust
That's
her
too
with a
bad.
lot of money,
That's too
and
bad.
put it into a trust. But there's variations on that theme that people can put into their trust, and on a regular basis, I have people come in who say, can I do A, B, and C, and how about E, D, and F, and um, the or D, E, and F, as it might be. In any
Uh-huh.
event,
Sure.
the yeah, as
Well,
long as it's unambiguous, you
right.
can. And
Well, it sounds like, I mean, there's really a lot of, I mean, everybody's different, and there's all kinds of different situations and scenarios that's going to be set up for each individual's circumstances in their own home, their own families, and whatever. And so, folks, look, I just encourage you. Give Ed a call, his team at Gudeman and Associates. Okay, wills and trusts now. Remember, Ed and his team, Ed's been doing wills and trusts literally for decades, several decades. You're not going to get more experience, more knowledge, more expertise than Ed. And you hear me say all the time, it's so important that you have your will and your trust done professionally, legally, in a legally sound way by a professional attorney who specializes in this. Don't try to, oh, I'm going to do that. It's the do it yourself kind of cheap online stuff, right? And try to save yourself a buck with the online templates. Well, but these templates are put together by attorneys. Yeah, but everybody's situation is different. And if your kids are going to end up in probate anyway, why waste any of that money? Get it done right. And you've heard me say many times, you try to get a professional attorney who specializes in wills and trusts to do it legally sound for you, you're usually going to pay anywhere from $3,000 to $5,000 for that. Ed Gudeman is offering you, my listener, a special. All you got to do is say, "Hey, I'm Bob's listener," and you can get it for $1,800. And you know something? Not 1,800 a piece, 1,800 combined for a married couple. Ed's willing to do it for you for, and 1,400 for an individual. You cannot beat it. Give him a call right now, and he'll meet with you for free. Free, no cost, no obligation consultation. All right, 248 546 2800. That's 248 546 2800. It's Wills and Trust now, Ed Gudeman of Gudeman and Associates. And Ed, it's always good talking with you. I appreciate you spending a few minutes with me today. Thanks a lot.
very welcome, Bob. Thank you.
You bet. Hey, take care now. You're listening to The Bob Dutko Show.